Thank you, Madam Deputy Speaker. May I associate myself with the comments today about the Duke of Edinburgh and Dame Cheryl Gillian. Madam Deputy Speaker, if we want to tackle violence against women, we need to change the conversation. We need to stop asking how we keep women safe, and we need to start asking how we stop the violence. I want to pay tribute to the many organisations and many members across this House who have devoted time and effort and energy to this bill and that conversation, whether Safe Lives, Refuge, Women's Aid, Southall Black Sisters, Laura Richards, to name but a few of the many. The bitter reality is that whatever political perspective we have come from, we have all known in the many years we've worked on this legislation, it is a once-in-a-lifetime opportunity, because the conversation has all too often been about how women should keep themselves safe, rather than our responsibility to free them from harm. I welcome the agreement of the government to many changes to this legislation along its journey. Just today, we are discussing their acceptance of Lord Kennedy's amendment to stop doctors charging for medical evidence for domestic abuse victims, for example, to the changes on revenge porn, to treating crimes motivated by misogyny as hate crime and ensuring that the Police Act to record how hostility towards someone's sex or gender means women are targeted for assault, abuse and harassment. But in the time I have today, I want to urge the Minister to go further and to drop the government's opposition to those amendments where we ask a victim to fit a particular box rather than recognising that they all need our assistance to stop the violence. Amendments 1 to 3 recognise the abuse of disabled people by paid or unpaid carers. And we know that disabled women are twice as likely as their non-disabled counterparts to experience abuse. It is from those who we seek to support, our disabled sisters, who are their intimate contacts, people who we trust to undertake some of the most sensitive acts, whether personal care, emotional or financial matters. The Minister says that she can't accept these amendments because by giving those people who abuse their carers the protection of this bill, it would change the common law understanding of what domestic abuse is and somehow dilute the purpose of this legislation. But the point about this amendment is exactly about changing our understanding of what is abuse and where it happens and recognising who suffers from it. That this abuse takes place in a domestic setting and it is the result of an intimate relationship. For too long, those affected have been telling us about reviewing their evidence and saying that somehow they have to prove their case of why they can't keep themselves safe through existing legislation. It is time to recognise if we want to stop violence and abuse, we need to act and change the way we think about domestic abuse accordingly, and that's what Amendments 1 to 3 do. Many have already spoken about Amendment 41, because that ensures that we give migrant victims of abuse the help they need to leave abusive relationships, whatever their status. Without it, the government is asking us to make a decision on whether to keep a victim of violence safe, not on whether she's at risk, but whether she has the right stamp in her passport. It is a speech for another day, Madam Deputy Speaker, about the dysfunctionalities of the UKBA and its ability to manage our immigration service. But it is a simple matter of fact that for many victims of domestic abuse, they cover the cost of them getting support and help and access to a refuge through their ability to access public assistance. When we deny women access to that assistance due to their immigration status, we consign them to having no way out of harm. And indeed, as Refuge have pointed out, the numbers of survivors of abuse with no recourse to public funds is likely to increase post-Brexit under our new immigration proposals. So the need to address this is going to become even more pressing. The Minister said that migrant victims should be seen as victims first. Yet, as she can see from the super complaint and the evidence it reveals, the reality is they are all too often treated as potential criminals first and foremost when they come forward. We need not only to safeguard them from having their data shared, but give them protection from being exploited full stop. And that is what Amendment 41 does. Because there are contradictions already exposed in this debate. The Minister says that the key consideration for migrant victims is not their immigration status with one breath, and then says that victims of domestic violence should not have an automatic right to status in the UK. She says she needs more information and claims that these amendments are unnecessary as a result because she's reviewing the matter. I tell her as somebody who's had to deal with these cases in my constituency and who is a big, big fan of the work that Southall Black Sisters do, we don't need more reviews and more evidence because the evidence is painfully already there. She says there is support, but we know in 2019, for example, 4 in 5 migrant women were turned away from refuges due to their no recourse to public funds status. We have seen firsthand the women kept in those violent relationships because of their immigration status. We have given the testimony of the culture of fear they experience, not only of their abuser, but of the officials who are there supposedly to help them. I also say, as a former member of the Council of Europe, who had the privilege to serve on the Council of Europe alongside Dame Cheryl Gillian and learn from her in that institution, we cannot ratify the Istanbul Convention while we try to draw a distinction between women in the help they can get access to. Ministers told us that this wasn't the case, for example, when it came to treating women in Northern Ireland differently to do with their reproductive rights. And quite rightly, the Council of Europe told them otherwise. It is the same when it comes to drawing a distinction between migrant women and whether they can access support for being victims of domestic abuse. It is long overdue that we ratify the Istanbul Convention. We cannot let this stop us being able to do that, as one of the few countries left in Europe has yet to do it. And I ask the Minister to talk to her counterparts in Europe to recognise how this will be a barrier to do that, as well as leaving women at risk in our communities. Finally, I want to turn to Amendment 42. Again, another matter on which there is much agreement in the House we need to act. But it is the best example in these amendments of how we can change the conversation and stop the violence that is caused by serial perpetrators and stalkers. The Minister tells us that this amendment isn't needed, that it isn't about the category of an offender, but how MAPA processes work and how her proposals for reform will address that. I understand the point that she's making, and I can see that there is some truth in the argument she's making about how services need to work together. Because the evidence shows time and time again, serial offenders, serial stalkers were left to target women without intervention. That for years, women have lived in fear and begged for help from the police to protect them, only to be told that they were being overdramatic. That's not me being overdramatic. Research shows how the constant dismissing and downplaying of stalking's serious nature means that on average, victims of the crime don't report to the police until the 100th incident. Shana Grice was fined for wasting police time before she was murdered by her stalker, a man who had been reported by 13 other women for stalking. Alice Ruggles was murdered by her ex-partner in 2016. The court heard how a restraining order had been taken out by an ex-girlfriend of his just 3 years earlier. But at the point at which Alice was begging the police for help, Northumbria Police had no knowledge of this. Janet Scott, Pearl Black, Lena Kenzer, Maria Stubbins, Kerry McCauley, Molly McLaren, Holly Gizzard, Justine Rees, Kirsty Treloar, Jane Clough, Lindsay Ashton, all of them cases in which serial perpetrators who had been violent and abusive to other women were involved before they were attacked. Minister, no one joined the dots. No one asked if they were at risk and acted. These women were sitting ducks. That is the system that you are defending today. The former Prime Minister says that putting someone's name on a list doesn't make a difference. Frankly, I disagree. It means that we can finally hold the police, not the victims, to account, because they would have direct accountability for the management of their behaviour. It makes stalking something the police have to recognise in its own right as something they need to stop, rather than something that women have to prove and manage. I pay tribute to the work that Laura Richards has done tirelessly to expose this situation and to fight for these changes, and to the noble Baronesses, Baroness Royal, Baroness Newlove, and also to Lord Russell for their work in the other place on this issue. Minister, we know this bill has been a marathon, but we are asking you to keep going just that extra mile, to use this once-in-a-lifetime opportunity, to stop trying to defend the indefensible and the status quo, and to change that conversation so that we can stop the violence, to not allow perpetrators of these crimes to use these loopholes that these amendments close to continue the abuse. The evidence base is already there. It just now needs the political will to act. And I say to the House, if the Minister won't listen, we must vote for these amendments.